May 11, 2012. This is Justice Done Dirt Cheap. On our way down to file a notice of motion for leave to appeal. Now the matter that is being filed today is regarding a decision that was rendered May 4, 2012, and that decision was regarding a referral, and the referral number is FM 111 and FM 2211. What's interesting is this decision was a long time coming. The original hearing was August 11, 2011, and it took until May 4, 2012 for the judge to render a decision. Now I'm filing for leave to appeal because there's a question of is this a final order or not. I don't know conclusively. I would think it's a final order or decision because there's nothing further that I can do in that file. I had my hearing for the referral, the matter's done, nothing more can be done with it as far as I know. But as a cautious step, I'm filing for leave to appeal so that there can be a judgment where other people may have filed for a referral, received a negative judgment, as in a dismissal of their request for a public body to produce documents that they're refusing to produce. So I haven't found one yet, so it'd be good to get it on the books to show that when a court refuses to grant disclosure, then it's considered a final order. There's no need to file for leave to appeal. One can file an appeal. So today we're filing a notice of motion for leave to appeal, supporting affidavits with the New Brunswick Court of Appeal. I found many reasons why I believe this decision is wrong. The judge who was presiding gave references to acts that do not exist, stated abbreviations for acts that I don't recognize, and made reference to chapters in statutes that do not exist. Besides that, the judge was highly critical of me in the decision. I believe that I have good cause to file for leave to appeal. I believe the judge's decision was wrong, for one. I believe that the judge has demonstrated reasonable apprehension of bias. Now all one has to prove is that a reasonable person looking at the situation, understanding the facts, can see that it's reasonable that bias may exist. It doesn't matter if there was real, actual bias, as long as there's just reasonable apprehension of bias. The other thing, I believe the judge made many statements that were errors in fact, which means the judge misunderstood or misapprehended the material before the court. And I believe the judge made errors in law, which is a misapplication of the statutes that were considered by the court. Now those are all grounds for appeal. There's a final one. Wow, is it ever windy today? The final one is escaping me right now. Oh, the right to be heard. The other one is the right to be heard, and I believe my right to be heard was violated because I had filed a recusal motion where I wanted this particular judge to recuse herself from any further matters regarding me, because I believe over the past 5 hearings the judge has consistently demonstrated reasonable apprehension of bias, has made decisions against me that do not make sense to me. So I think there's an issue with this judge and me. I want that judge to recuse herself. And at the hearing of this, last time I was before the judge was April 27, 2011. At that hearing, as a preliminary matter, I brought up the recusal motion. The judge refused to hear the preliminary matter, which is the recusal motion, and ordered me to begin my presentation regarding another matter, which was whether the court would order that there be an extension of time to file and serve a post-hearing brief that was relevant to the same referral that I'm appealing today. Now, I believe the judge should have recused herself, and on an oral motion the judge should have allowed that and just stepped back and honorably said, okay, it's enough material before me. The court should just step down, but the court didn't. What's amazing is that since then the judge has rendered decisions against me, one after the other. I don't believe any of them are reasonable. I think there's an issue between me and this judge. The judge has repeatedly in written decisions stated that she doesn't understand my material, she doesn't understand me, she thinks I'm difficult, she thinks I'm argumentative. What's amazing is that the court of law is where one presents argument. Of course one's going to be argumentative, because that's the point. But one should not have to be arguing with the judge to get a fair hearing. A judge is supposed to grant a fair hearing as a right. Everyone in Canada has the right to a fair hearing, which means to be before an unbiased court, rendering unbiased decisions. The court should allow everyone to be heard completely, and if the court does not understand something that a party's presenting, the court has a duty to ask questions for clarification. It's okay if the court does not agree with the party, but it's not okay if the court just doesn't understand the party and doesn't make any effort whatsoever to gain clarification. It's the court's duty to be clear about the arguments presented to them, weigh out the argument, the authorities, common law, case law presented, the facts as presented by affidavit, and then render a decision based on all that. If along the way the court left some of that out, then someone received an unfair hearing. And in Canada, you have a right to an impartial adjudicator who is following procedural fairness. So, I just wanted to share that thought. Going on a file leave to appeal today. Let's see how it goes. what I'll do is I'll be eventually putting links in the description area where you can see a copy of the documents that I'm filing today. So this is May 11, 2012. Just done dirt cheap. Thanks for listening.